Start. Yes. Having regard to the finding of the High Court that the respondent had not treated the appellant with cruelty and was compelled to leave the matrimonial home on account of the conduct of the appellant, a different approach was taken on behalf of the appellant at the time of hearing of the appeal. It was sought to be urged that even if the appellant had been unable to prove his case of cruelty and desertion as the grounds for seeking dissolution of the marriage, having regard to the irretrievable breakdown of the marriage, technicalities should not stand in the way of this court granting relief to the appellant in exercise of its power under Article 142 of the Constitution. It was submitted that out of 16 years of marriage, the parties have lived separately for 14 years, most of which has been spent in acrimonious allegations against each other in the litigation embarked upon by both the parties. It was submitted that there was no possibility of retrieval of the marriage and appropriate orders should be passed to end the agony of both the parties. Since initially, on behalf of the respondent wife, it was made to appear that she was ready and willing to go back to the appellant subject to certain terms and conditions. We explored the possibility of an amicable solution, but such an attempt ended in failure on account of the rigid stance taken on behalf of the respondent. On behalf of the wife, it was submitted that certain orders had been passed by the courts below for payment of alimony by the appellant to the respondent, but that the same had not been complied with. It may also be mentioned that a male child had been born out of the wedlock, and we had hoped that the child would act as a catalyst for amicable settlement, but even the existence of the child could not bring about a reconciliation between the parties. The prayer made on behalf of the appellant and endorsed by the respondent is neither novel nor new. At the very beginning of this judgment, we had referred to the decision of this court in the case of Ramchandra (Supra), where it was held that when a marriage is dead emotionally and practically, and there is no chance of its being retrieved, the continuance of such a marriage would amount to cruelty. Accordingly, in exercise of powers under Article 142 of the Constitution of India, the marriage between the appellant and the respondent was directed to stand dissolved, subject to the condition that the appellant would transfer his house in the name of his wife. Having considered the materials before us and the fact that out of 16 years of marriage, the appellant and the respondent had been living separately for 14 years, we are also convinced that any further attempt at reconciliation will be futile, and it would be in the interest of both the parties to serve the matrimonial ties, since the marriage has broken down irretrievably.